Hello and welcome to the Great Legal Mind Show. Today we are glad to have someone who has pioneered arbitration in India. He's one of the first ones to have started arbitration and advocated that. And I'm sure you would have guessed the name already, but let me welcome Mr. Hiroo Advani to the Great Legal Mind Show. Sir, a very warm welcome to you.
Thank you very
Uh,
much.
And today, actually, we see, arbitration has picked up a great pace. But what has also happened is that we have seen many, arbitrations awards are then challenged in the courts. Um, as someone who understands this in and out, I wanted to understand that, um, how it is going to pan out in the long term, and if this keeps happening, then doesn't it defeat the purpose of arbitration completely?
Okay, let me start at the early days when I actually started as a counsel in court. My father was an eminent senior counsel, and I started in his chambers. And to me, the pace of work was quite slow because you would very often go to court and your cases would be adjourned. Or as a junior counsel, you would have relatively smaller matters to argue, which didn't quite perk up your interest. So I happened to meet some Americans who were doing business in India and in the oil and gas sphere. And a lot of them, very interestingly, were working in Bombay High, which had just started producing oil. And two of them, most interestingly, started as divers in Bombay, because in those days you did not have Indian divers, you only had foreign divers who had the experience. They'd actually made money from Bombay High, gone off to Harvard Business School, and were now the head of their companies. So it was an interesting mix, and they said, look, we're doing all this work against ONGC, Oil India, Director General of Hydrocarbons, and because they're running in a bureaucratic manner, we are never able to see the conclusion of the contract by recovering all our money. There's always 10 and 15% left over, and 10 and 15% of a few $100 million is quite a lot of money. And they say, we don't have these margins to work with. So we advise them to start arbitrations. And that's how we started. And we started with very, very big arbitrations with American companies. So, of course, as a young counsel, it was very attractive because you got paid about 25 times the amount you got paid when you went to court, because you were doing fairly large claims, and that went on. So the interest began there. And particularly with Americans, they have a different philosophy. They don't quite understand the Indian and the English system, where you have solicitors, counsels, barristers, senior counsels, etc. As far as they're concerned, they want one person to deal with. And they had a strategy and had taken a board decision. They will not deal with individual lawyers. So that forced me to start my own law firm, because otherwise they could not deal with me beyond the odd case. And that gave a very big boost to my career because it started working well. And like you said, that because the arbitrations are getting stuck in India, we started getting smart, and whenever we could persuade the authorities to have an international arbitration. So in those days, Zurich and Geneva were the much preferred options. And we started doing quite a lot of work in Geneva and Zurich. And it was all very exciting stuff to almost start your career with international arbitration rather than domestic. So you were traveling all over the globe, doing all this work, international arbitrations, delivering a result in 2 to 2.5 years, sometimes 1.5 years. Your clients are very happy with you. And they, in those days, American firms, like they do even today, had no issue of paying you bonuses if you succeeded in the matter. And they saw success, they wanted you to see success. So that helped me build a firm with arbitration work. And then I initially, with my firm, said since it's a law firm, I shouldn't confine it to only one sphere. I should sort of confine it to other things. And so similar clients were doing acquisitions in India, and so an M&A practice now started. But then it kind of went around the full circle because I was finding it very difficult to run and grow a law firm, at the same time argue the main cases myself, which I was doing. We never engaged any outside counsel. So I was arguing the main cases and trying to run a law firm, which then started becoming burdensome because you're against competition, which is the best minds in the arbitration on the other side. So you need to match them in terms of quality. And so therefore, I decided to once again focus on arbitration only. Then it almost went through a full cycle where the domestic claims became much larger than the international ones. Because by the time now, when we were trading on the international one, we were obviously trading on the toes of some of the larger firms in the world globally. And they started getting the bulk of the international work, where we continue to get some, but not the kind of quality that we started with. And we started getting that quality in India instead, because the international law firms weren't in India.
Right.
So we started running the biggest of claims in India, and then now confine and much prefer to do domestic arbitration rather than international for two reasons. Like you said, in India, the stumbling block.
Yeah.
International arbitrations don't want to come here if they can help it. They want it out of India where they finished in a timely manner and concluded. And they didn't want to face all the court proceedings in India, which can go on for 5, 7 years, 10 years. But there's a major improvement in Indian arbitration because unlike any other arbitration act in the world, they've actually put time limits. There's no other arbitration act or institution which has time limits on the arbitration. I appreciate sometimes the time limits are not honored and parties keep asking for extensions. And in my view, the courts wrongly give extensions very liberally rather than coming down very hard on them. So they spoil half the reason of it. The other major improvement is the fact that if you want to challenge an arbitration award in India, even if you're a government company, there's a judgment of Justice Nariman which says, as far as the Arbitration Act concerned, even if you're a government company, you're just one more party. And therefore, if you lose, you will deposit the money in court. And usually varies court to court with 100% of the money. So it has improved to that extent that if another party wanted the money, he does put up a bank guarantee or some kind of security, but at least you've got your money in a reasonable amount of time. Yes, there's a cost of guarantee and there's a cost of doing that, but that's the cost of doing business. At the same time, your cash flow of millions of dollars is not blocked because you can access it.
Right.
So arbitrations in India have improved very considerably. But if you ask any reasonable arbitration practitioner in India, would you advise arbitrations in India or not? I think almost uniformly you'll get an answer no. Because in other places, the arbitration awards are not challenged so liberally. Courts don't interfere liberally. In Singapore, for example, which has become another stable place for arbitrations, the court will not take more than 1 year to complete your arbitration, whatever it is.
Yeah.
They will prioritize it. They want Singapore to stand out as an arbitration center. So they will prioritize all challenges and dispose them up in 3 months, 6 months, appeal court maximum another 6 months. So within a year, you're done with it.
But sir, what about the execution of those orders that are given in Singapore and all of that? How strongly they are executed in this country? I mean, if there are the strong parties are strong and they have clout and all of that, what we hear is that also becomes a bit of a challenge. Is that true?
I must say, speaking very highly of Indian judiciary, they seem to have a deep respect for international awards more than they have for domestic awards. So you have two things. If you are enforcing an international award in India, the New York Convention applies. You can enforce it in India, you can enforce it in some other countries, depending where the company has assets. But if you succeed in the enforcement at the first level, it's no longer an appealable order. You have to go straight to the Supreme Court.
Okay.
And you sometimes wonder, why don't they do the same thing with the domestic award? That
Right.
if it has one scrutiny of a judge who
Yeah.
says the award is an order, then why do we go to the second round of appeals, etc.? Why don't you just take it to the Supreme Court, which, as you know, in an SLP, can decide it in 5 or 10 minutes usually.
Yeah.
So there are ways and means where in some senses we're almost there, because enforcement becomes easy because they will not let you challenge it unless you deposit the money in court. So there's no, once the Supreme Court or the High Court dispose of your matter, there's no further around the challenge in trying to gather the assets, find where they're hidden, etc. So there is a considerable improvement in the arbitration in India, but it's nowhere up to international standards. The habit of appointing the retired Supreme Court judges and High Court judges seems unshakable in India and continues. And two things have happened. Some of the more popular arbitrators are just far too busy. So it seems almost practical to say that if you have either 6 or 8 or 10, whatever number you choose, arbitration, you cannot take up the 11th one till you dispose of some. So that you automatically limit the load that a man can take and put a lot of pressure on him to show better disposal.
Yeah.
And if you ask me to limit the arbitrators to 6 or 7 to which an arbitrator can take, you'll see how fast the disposal will change life totally. And it seems a very elementary logic, and also for some reasons that diversity, we are spreading so many more arbitrators. You're training so many more arbitrators because each man can't take more than 6 or 7. He has to decline them. So you'll have a bigger pool of arbitrators, a bigger pool of competent people doing it, speedier disposal. And if you can eliminate one round of elimination in the High Court, the next round in the Supreme Court is very, very quick. So we are hoping for some improvements in the situation as we go along.
Yeah, and we are hoping that India becomes the preferred place of arbitration as well. And so I just have one additional question here is that we also are hearing a lot of third-party litigation funding coming into the picture. Now, how does that actually impact the scene?
I'll tell you, there are several ways. Just to explain to your audience, third-party litigation funding is the fact that where one party doesn't want to spend all this money on lawyers and arbitrators and enforcement, etc. So there are funds which are established all over the world, largely Australia, England, now it's growing a little bit in Europe, and the US, which will fund all the costs. Simple as that. But of course, they won't fund the cost unless they've vetted your case and found it's an excellent case, number one.
Absolutely.
And number two, that the party on the other side has capacity to pay.
Right.
So,
right.
So that the first thing they will push you to do is try and ring fence some of the respondents' assets so that if we win, we have easy access to it. So you're almost worrying about enforcement before you start. And then they fund everything, and they also keep the pressure on you to speed up the arbitrations and not to adjourn things and let things drag on. Because ultimately, if you want work from third-party funders, you have to display that you're very quick on uptake and are willing to move things forward as fast as possible. It's against the idea conceptually in India of the old law, what they call champerty and maintenance.
Mm-hmm.
Where somebody would come and fund your litigation and say, fine, give me 50% of the winnings or 80% of the winnings.
Right.
But it's something that's been driven out of almost every common law country. And there seems no good reason why we shouldn't follow. The Supreme Court in one judgment has accepted third-party funding as a reality, is saying it. So, but it's more important to have ethical rules there. Because an unscrupulous third-party funder will come and say to somebody who is not very well off, I'm going to fund it, but I want 80% of the winnings, effectively buying you out.
Yeah. That does not sound fair also, I think.
Yeah. So therefore,
but that is true. Yeah.
So therefore, all jurisdictions have ethical rules on this.
Right.
Every jurisdiction that permits it will have ethical rules as to the extent you can take out of the winnings. Okay. And if you ask me, any Indian court would say this is if you are taking 80-90% against public policy. So you need to be careful that the third-party funding is well funded. Number one, the third-party funder doesn't run out of money halfway through the case, or says, I'm very distracted. I've got a bigger case, so I want to go there, and I don't want to spend money on this smaller case. So the rules control the third-party funders as well. What they can take out of the funding, the fact that when they sign up, then they have to have enough money to fund it all the way through, so long as there's some cooperation between the parties. So you don't want it to become a bit of a free-for-all. You need to control it.
Yeah, and these rules are set for third-party funders already because, this is a very recent phenomena. So what's the, state of...
every sophisticated jurisdiction that permits third-party funding has these rules in place, including bar council rules of how funders should behave, the rules that funders can't pull out. And equally important, and this is now happening in most jurisdictions, the arbitrators have a right to ask you, we want to see the terms of your third-party funding. Your third-party funding, please disclose it.
Oh, okay.
So, and they do regularly ask for two reasons. One is if there is a completely impecunious party who's doing all the litigation, then a cost award can't be enforced against him because he doesn't have the money. Right. So they have been known to order costs against a third-party funder, saying you're funder, so you'd run the risk of costs as well. Secondly, in England, they've taken even a more mature view, which involves an Indian party, incidentally, against SR.
Okay.
Where they said that as a matter, when you succeed, we will even pay you the third-party funder's cost. So the third-party funder is getting 30% of whatever you have won. They will add that to the cost claim. That has been upheld by the Court of Appeal in the UK. I'm fighting one like this in the Bombay High Court, where I've got an order of that sort for a Singapore arbitration in enforcement. I, of course, will have to see wait and watch what attitude the court takes towards it. And the cost order includes the third-party funder's profits.
Yeah, but these rules, you've talked about, a lot of jurisdictions. What about India? Those rules, are they written down somewhere? Or it's unwritten code of conduct, what it is?
In India, they simply don't exist.
Okay.
We just, as usual, with a lot of newer legislation or newer types of litigation that come out, just turn a blind eye to it.
Yeah,
you must understand on arbitrations against the state, when you have claims against the state, almost 30% are third-party funded. The claims are very large, so third-party funders are attracted to that, but almost 30% of those claims are third-party funded. And on international arbitration, the numbers are creeping up to something between 12 and 15%.
Okay. So what about, sir, another thing that I wanted to actually talk about, which is, prevalent in a lot of developed economies is, this conditional fee arrangement. It doesn't exist in India, right?
No, it doesn't. It doesn't, although, again, the Supreme Court took a different view. They said the lawyer who is instructing, we can understand he has a conditional fee arrangement that I'll get paid extra or I'll get paid if I win, but not the senior counsel.
Right.
So they disallow the senior counsel's fees, but these are all very old judgments. I don't think the courts have really applied their mind to the issue in more recent times compared to what's happening in other jurisdictions. Otherwise, many a lawyer would be happy to do is say, look, since you can't afford the fees, and some of the lawyers or the law firms are well off, we'll fund it, but we'll take out 15-20% of the winnings. And they act almost like a third-party funder. They vet your case, think it's a strong case, they can recover the money, etc. There's a certain amount of enthusiasm put into the lawyer then, because he's going to come out of it with a lot of money.
Right. Absolutely.
So these are all methodologies which are tried and tested in other jurisdictions. There seems no reason why our law ministry can not broaden its approach, see what's happening in other jurisdictions, and consider if it's appropriate to the Indian conditions. To my mind, once you are involved in international arbitration, and many of them are against Indian public sector companies, a lot of them are third-party funded. So it's already there in India indirectly, but through international arbitration rather than domestic. So why can't we broaden our approach and legitimize the whole process now?
Absolutely. In fact, another thing that, within this, I want to actually talk about some of the things that we are seeing now, which is, say, electronic discovery, how it is going to play a role in litigation in India.
Well, I think it's fascinating because don't forget, electronic discovery, if you attempt it, it's a huge volume. Normally, you're able to say, I want to see this letter or this agreement has not been suppressed or something, a handful of documents. But electronic discovery will be files and files and files. And the bigger issue is, and some jurisdictions are confronting it, how do I know you disclosed everything to me? You put it there. How do I know?
Right.
Do I now have a right to come and examine your computers, bring my own software team, go through your computers to make sure that whatever the arbitrator has ordered, the extent of discovery, I've got everything.
Right.
Because mails can be tampered with, they can be hidden, they can be fabricated. So the whole cyber issue has gone to the next level. And the only way I can verify it or dispute it is frankly have access to your computers to make sure that I do it. And if we have a lot of confidential stuff in it, okay, let me appoint a neutral cyber expert who can go and do it. Just to ensure that I've got what I've asked for, what the arbitrator's ordered.
Right.
This is happening everywhere in the world now, where I will dispute that the following mails are all fabricated or hidden or not. And cyber experience has now gone up to the next level where these issues can be verified.
Right.
So if it is verifiable, and I go to the arbitrator and say, look, the other party is playing all sorts of games, these are critical documents, these are critical sets of accounts which I need to see. Why can't my cyber expert sit and look into their system to see I've got everything I've asked for? Courts have now started ordering that and permitting it. So it's completely new. In India, the feeling, especially when you work against a public sector company, that because they're a public sector company, whatever they're doing is confidential. You can't see it.
Yeah, absolutely.
But I think the reality of the law is different.
Yeah.
You have a right to it, unless it's confidential information between you and your lawyers, which may be privileged.
Yeah. So besides that, everything else can be, scrutinized. If that is happening, I think it is going to be much more sharper now moving forward.
And it'll be fun to see if you get an order from overseas, giving a right to go and examine the company's computers, what will the Indian law react to the computers are sitting in India?
Yeah. Right.
Can you then go to an Indian court saying this is completely impermissible? I have so much confidential information. I can't do it. How can they be allowed into my computers, into my office? But it's going to happen. It's a wave of the future. It's inevitable.
So, sir, with this, we have actually completed segment 1. We will edit this out, which I'm talking right now. And now I'm going to ask you, in fact, one thing that you said that, you were doing arbitration and against a lot of big seasoned guys, and therefore you must spend your time on arbitration rather than kind of the management of the firm, the business of law side, that is where I actually have a related question, which I'm going to ask you now. That, how do you think it is going to evolve? Like, in like London or US, even in Singapore, I mean, a lot of, the firms are also have professional staff to kind of look after the business of law, whereas lawyers are more focused towards the practice of law. And how do you think that is going to evolve in India? And could that have helped you
I don't think
in your own practice?
I don't think it's absolutely clear cut, and I'll come to that. I think most law firms globally will still have a senior partner and a managing partner who are actually lawyers, who may not have time to practice law, but who have grown with the firm, know the personalities, so they may hire a global strategist to help them in strategic planning, in running, or in HR, or in PR, in different segments. But still the least experienced people are running the law firms because they're still originally lawyers. The managing partners, senior partners are all elected in large law firms. And they're elected because they're well-known lawyers and have done a great job or are huge rainmakers. But they're probably not ideal to run the firm. Also, they do handle outside people as strategic partners and all that. But very seldom you will see a law firm run with a CEO who had nothing to do with the legal practice.
Right.
Who looked at the finances, who looked at the hiring policies, who looked at the growth, where the firm should be, but who not grown up as a lawyer. So it is slowly evolving. One or two firms are experimenting with a CEO who has more of an MBA or financial background and not a legal background.
Yeah, because it takes about, like, if you actually look at your own example, that I'm sure that would be taking about 30-40% of your time, and which you could have spent on your core area, arbitration. So in that sense, I mean, how hopeful you are that this is going
so
to.
You also have that side of it evolving internationally.
Right.
That many of the leading arbitration lawyers with the biggest law firms have all broken away from the law firms. And the prime and the first example was, I don't know whether you call it a chamber or a law firm called Three Crowns, which comprise only of arbitration lawyers.
Right.
So they're not involved with management of law firm, et cetera, et cetera. They are simply lawyers who are now going to practice arbitration. It started with Three Crowns, then you have the arbitration place, et cetera. So there's a growing tendency for arbitration practitioners to break away for two reasons. One is they only want to do arbitration, which is work-related and not management. And secondly, because of conflicts. If you're sitting with a large law firm, most of them want work from the large banks and the large institutions, so won't want to act against them in arbitration. And half the time, even if, unlike India, the international arbitrations are not retired judges, they are practitioners. So they're always being conflicted out. So in order to prevent the conflicts issue, as well as the management issue, we're now finding series of international specialized arbitration law firms which do nothing else but arbitration. It's a growing tendency.
So that's the alternative. That's a solution that they found to, I mean, I think, which also makes a lot of sense. Now I have, one or two questions related to Hiroo Advani per se and not the practice of arbitration. One question is that, what if you were not a lawyer? What you would have been? What's the other thing that you prefer being other than being a lawyer?
Well, that's a big question. I'm torn between two things. One is I'm very fond of light fiction. And I'm very happy reading light legal fiction, particularly people like well-known people like John Grisham and all. Okay. I'd love to be a writer. I'm not sure I had the skills or do have the skills, but it's certainly a first love of mine.
But lawyers, as it is said, that there are great storytellers. I mean, if you're a great storyteller, you will go very well in your profession.
But the second thing is a little bit of fear of failure in case you fail. and legal writing in India has not picked up the way it has internationally. We did initially quite a lot of M&A work. And on 2 occasions, because it was an international company taking over an Indian company, because we worked so closely with them, I was in fact offered a CEO post to come and take it over and run it. And frankly, that was a huge, huge temptation to just quit the law and go run a company, because it's a strategic fit, something I knew nothing about, and learn a whole new business of running a company as opposed to being a lawyer. I didn't go for that. One was because we couldn't agree on the remuneration. And the other one was a relatively smaller acquisition where I'd be reporting to far too many people overseas. And having run my own law firm, wasn't quite used to, or wasn't ready to stomach that yet. But that was a very serious temptation I had. And the other one was writing light fiction. But there, frankly, the fear of failure came into me.
But that you can still do along with what you're doing. I mean, I think that would be a lovely thing to see for your followers. So I think this is great, and this is my last question of the interview, which is that what is that one message that you wanted to give to the younger lawyers, students, because you have seen say for example arbitration evolve quite a bit. What is there to come, and what is your message to the younger generation?
The answer is to recognize what is happening internationally and specialize, and more specialization. There is no point in a very old-fashioned attitude of trying to do everything and be everybody to everything. So if you specialize, you'll get more satisfaction from your work, you will deliver a better quality, and ultimately, I think you'll be a better lawyer rather than trying to do 6 different things and not being very good at any of them. I think that includes counsel and court, and we are hoping that it includes judges. It's so obvious in the Supreme Court. When you see the judges who have come from commercial cities like a Bombay or a Delhi or a Calcutta, the way they handle commercial work in the Supreme Court, and the way someone who's come from a much smaller place, who hasn't had the experience of commercial work, they're almost at sea on commercial work. Fortunately, I think the Chief Justice recognizes and now assign work accordingly so that the work in the Supreme Court doesn't suffer and it's handled well. But I think specialization is the name of is the way to go. And for every lawyer, within the first 5 years, you should specialize and go ahead. Otherwise, quit being a lawyer.
Thank you so much, sir. I think it is a fantastic message. And with this, we end this absolutely insightful discussion with Mr. Hiroo Advani. Thank you so much for being there.
Thank you very much for having me. And it's been a pleasure talking to you.